the essentials of a plan for your future. This is me, and this is just about the last you'll see of me, other than directing traffic when it comes to answering questions at the end. I'm Joanne Robson, Provincial Education Coordinator at the Alzheimer's Society of BC, and we are very fortunate to have Joanne Taylor presenting our workshop today. Joanne is the Executive Director and Registrar of Nidus Personal Planning Resource Center and Registry. She has really been in this field right from the get-go. She was involved laying the foundation for the legislation that got registration or representation agreements up and running, and she's been with them ever since. She is, there's probably almost no question that Joanne can't answer. She is an absolute fount of information, and she's a pretty engaging presenter too, so we're really lucky to have her. She's also one of the busiest people on the planet, so if you manage to pin her down for an hour and a half for a teleworkshop, I think that's a real coup. So I'm really pleased to have her here today. So with that, I will pass it over to Joanne, and she'll do the thanks and disclaimers here, and she'll move right into the presentation, and I will get off the side of the screen here, so it's all over to her.
I'd just like to remind us that what I'm going to talk about is not legal advice, but hopefully enough information to help you move forward. And I'd just like to thank donors. We are a charity. We don't get any funding to do education, so we're very grateful for donations to help us. And I think I just clicked to, how do I move us forward?
Click the arrow first, Joanne, and then after that you can just use the arrow on your computer. But click the arrow on the screen first.
Okay, not that arrow. Okay. There we go. Okay, when we're thinking of planning for the future, we're thinking of planning in case of incapacity, for end of life, other support needs, and after death. So this will obviously be a brief run-through. And first of all, to give you a little bit of background on Nidus, as I mentioned, we are a charitable organization and a nonprofit in BC. We were established in 1995 by other community groups, including the Alzheimer's Society of British Columbia. And we were set up because those community groups and citizens have been involved in a grassroots law reform of adult guardianship. And I'll tell you a bit more about that. But out of that law reform came the Representation Agreement Act, and they set up the Resource Center so people could have access to information and assistance. So I call us the hub for expertise on representation agreements. We have a lot of other knowledge as well, but that's our specialty. And so we're a resource to the public, community organizations, and professionals. And part of the work that we do is providing a registry service, which helps with communication of important information and documents. And I'll tell you a bit more about the registry. The term Nidus is Latin for nest, because we like that symbolism of support and safety when you think of the nest. And here's just another way of thinking about Nidus, because it's kind of graphic. Maybe it'll stay in your mind better. So you see the three circles, and I'm really just trying to show you that it's a very dynamic kind of organization, and I'm calling it participatory approach because we are very rooted in people's experiences. Like, people tell us how things are going, what's happening, and that helps us in our education. So the Resource Center is the place for education and assistance, and our registry service is about connecting information, the right information to the right people at the right time, very critical for this area, but also today's world. And then, of course, our feedback group side with the information that we get and that we think hard about, and we have a practice advisory group, I call it, with community and legal experts who help us understand some of what we're hearing and share that back out with people. So that might be, you know, there might be a media article, there might be a court case, there might be some policy that's coming down from government, and we're looking at it and saying, well, how's that going to affect people? What do we have to let people know? So you can see that it's, you know, very grounded, but with a lot of disciplines and expertise. And the law in this area is also very dynamic and emerging. So this is, we're on the forefront, and you can, you know, keep up with some of that by keeping in touch with Nidus. So let's move forward on the planning side, and we've put together a diagram just to help us with some terminology and some ways of thinking about these concepts. So for example, we're using the term personal planning to differentiate from estate planning. So estate planning, which is what I'm actually going to talk about first, is about making arrangements for after death. And personal planning, which we'll talk about next, is about making arrangements for while you're alive. So that's kind of the first brush at this topic. And if I said to you, what is the legal tool for making arrangements for after death, I'm sure you would all say will. That's kind of in the public dictionary. We know that term. So I'm going to just briefly talk about the will and the requirements in British Columbia, because each province has their own laws about wills. And there's a new law actually in British Columbia created by government in consultation with lawyers, the typical way that law is made. And this new law came into effect on March 31st, 2014, and it's called the Wills, Estates and Succession Act. But if you want to show off, just refer to it as WESA. And everybody will think that you're a lawyer or you hang around with lawyers, because that's how they call it. Of course, you may already have a will. You do not have to make a new will only because we have new legislation. But if you were to update your will or make one for the first time, then you're going to make it according to the rules of the new law. And under the new law, you must be mentally capable and at least 16 years old. And mentally capable means that you must understand the nature and effect of making a will, and you must be free of mental disorder. And I was reading some of the education that they use with new lawyers, and they make it very clear that just because someone has a diagnosis of dementia doesn't mean that they have a mental disorder. We're talking about maybe a later stage, advanced stage of dementia, where someone doesn't really understand, you know, what a will is for, or maybe they don't remember how many children they have, something like that. So it's good that some of that education is getting out there about diagnosis does not equal incapability. And of course, what you're doing with a will is you're appointing someone to settle your estate. And your estate being what you own and what you owe at death. And the person you appoint, we've used the term executor. The new law is kind of using the term personal representative, which is a little bit confusing, but it's the same as the idea we have of the executor. And be sure to ask that person if they're willing to do it. And you should also have a backup because, you know, something might happen. And I don't know if you knew, I didn't know until I did some research, the executor has legal authority to decide on the disposal of your body, whether it's by burial or cremation. But you can have your say if you put it in writing in your will, which you want, and then your executor has the legal authority to carry that out. If you don't put anything in, then they are the ones who decide and make that happen. And this is a good reason why you want to be communicating with your executor and probably other people about what your wishes are. And we would recommend that people go to a lawyer or notary public to make their will, because especially since the law is new and there's always transition things, they have access to up-to-date information. There is a registry for wills. It's run by the BC government, and you can register what's called a notice. $17. You can do it online. It's through Vital Statistics. You can't store a copy of your will, and you can't go in and update your record. You'd have to file a new notice, a new wills notice, if you move or change the location. So it's just got very, very basic information. It was put together some 50 years ago or something, a long time ago. If you don't have a will, or you're not considered capable of making a will, there is a default scheme that decides how your estate is settled. And Nidus is going to write a fact sheet about that, because we know people worry about that. You know, mom didn't make a will, and now she's not, you know, the lawyer says she's not mentally capable of making a will. What's going to happen? And people worry. So we're going to write a fact sheet about that. Sometimes people don't make a will because they think, oh, I don't have very much. But I will tell you from personal experience that my spouse and I had everything joint, and it was pretty straightforward. When he died, you know, I thought, okay, everything's going to now be in my name. But, you know, a lot of places wanted to see the will regardless. So it makes things easier if you have a will, because then it's clear about your intent. And here's a little diagram I made up. It's not too fancy, but I'm hoping that it makes sense. And what I'm trying to show here is that your will, or what we call your estate, is in that circle where you will, you know, you can say what you want about burial or cremation. You name an executor and they have authority to do what other things you've said in the will. And that's going to contain, you know, money, maybe real estate property, maybe personal effects, jewelry, artwork, whatever it is. And they'll, you know, wrap that up. Sometimes people will do some other things with their money or savings or things like that. So they might put somebody's name on it so that it goes directly to that person, or we call them the beneficiary. So maybe you have a tax-free savings account, and you are, that's just an example, and you are able on that to specify who the money should go to, or it might be more than one person. So it would not go into your estate, it would go to that person unless they've died. And then, of course, if things are owned jointly, then they go to the surviving person generally. But I am going to tell you, and it comes up a bit later, be very cautious about putting anything in joint with anybody other than your spouse. So when I said, you know, my spouse and I had things in joint, like a bank account, the real estate, the car, that was with a spouse. The other sort of vehicle, as they call it, way that people sometimes, you know, look after their money separate from going into the estate is using a trust. I don't know a lot about that yet, but we're going to write a fact sheet about that. And it's something that the lawyer or notary public can explain to you. So I just wanted to show you that there are other ways that people sometimes do their estate planning, but the will is a key part of your plan. Okay, now we're going to talk about personal planning, which is really my favorite topic. So we're going to spend more time on that. And I've got another chart to show you, a graphic to show you what we're talking about. And you'll remember that I said personal planning was about making arrangements for while you are alive. So that's where we want to put the spotlight, because in the past, perhaps it wasn't quite as important. People didn't live as long. We didn't have technology to rescue us from car accidents and things, or intervene if we were ill. So the picture's changed. And under personal planning, you'll see that there's 4 containers, and they represent what I call life areas. They are, you know, ways that laws and policies kind of tell us how things will be dealt with. We don't live our life in separate compartments, but there are some laws and policies that speak to those. So we have health, personal, legal, and financial. And the next slide here shows some of the things that will fall under each of those life areas. So under health, we have medication, surgery. I'm sure you could come up with a big list around that. Under personal, we have decisions about where you live, diet preferences, exercise, activities, things that you like to do. It might involve arranging for services to come into your home. It might be consenting to facility placement. Those kinds of things fall under what we call personal care. Legal would be things where if you were in an accident, let's say a car accident, and need to settle up the insurance claim. Or maybe you need to get some legal information. Or maybe you need to hire a lawyer to help with your claim. All of those things fall under legal, and sometimes it involves going to court. And then under financial, banking, investing, dealing with Canada Revenue, selling a motor vehicle, and redirecting the mail actually is a financial authority. And sometimes though it's those little things that can really stop people in their tracks, and they realize, oh, I need some legal authority. So for example, I had to change the mailing address for my dad when he went into a facility. I can't just show up at Canada Post and say, you know, I'm the best daughter. Well, I'm the only daughter. I have to have legal authority to change the mailing address. So that's what we're talking about when we're talking about getting plans in place so people can help us if necessary. Now, if you notice on the chart, there's another container attached to health, and it's called advanced care planning, and it's the term that the health authorities and the Ministry of Health are using to encourage people to plan for health matters primarily, because that's what they're interested in. We're using the term personal planning because it's broader, and because we want to make sure people understand the relationship between all of these areas. So your financial resources are going to determine where you live, right? And they are also going to play a role in often decisions about eligibility or subsidy for certain health and personal care services. And that's usually determined by your income tax return. So if you can't get that information, somebody else is going to have to get it. So you can see why I was saying that it's important to look at the big picture, all 4 areas. I want to tell you a little bit about the law reform. Sometimes people say, oh, why do we want to know the history? Well, I think it's important because it tells us about where we've come, but also where we're trying to go. Because the law reform was guided by some very important principles, like the right to self-determination, the presumption of capability. One of our strong principles was around things being accessible, and we've got a long ways to go on that, I'll tell you. And that people should have access to support as needed. You know, it's not about taking over somebody's life, but if they need help in a particular area, let's be there. And maybe they'll need more and more help as time goes on, but we won't start from assuming that they need us to take over everything, right? And then another important principle was that adult guardianship should be the last resort. So these were principles guiding the development of the actual law, but they're still important in how we practice that law, how we put it into place. Another feature of law reform, which I call social change because it really is that these tools that we developed, like the Representation Agreement Act, is about investing in support from family and friends. So it's a community-based approach as opposed to relying only on professionals and government, because frankly that's not sustainable. And most of us wouldn't want a bureaucrat telling us how to live our life. And so we're trying to shift the service system, or systems I should say, away from paternalism to self-determination, right? So it's not, you know, government knows best, doctor knows best. It's that, you know, okay, give me your medical opinion and I'm going to hold that up against my values and beliefs about quality of life, and let's see what I can try and what will work for that. So that it's really about including the things that are important to us. And what we also obviously were trying to do is fill gaps in the legislative framework so that people could help themselves and each other. So here's my little chart of the gaps. So before February 2000, we had a legal planning tool for financial and legal affairs, and that was the enduring power of attorney. But we didn't have anything in BC to let us plan for health and personal care matters. And you know, frankly, that's often what people care about the most, the quality of life stuff, right? And we didn't have a legal alternative to adult guardianship, so that if people were not considered capable of making an enduring power of attorney, let's say, for their financial legal affairs, then they would end up under adult guardianship. So we wanted to create a legal alternative to that. So we have those 2 gaps. That's what we were really trying to do. And so what we did, or what came out of that, was what I call 2 paths for personal planning. So remember, we're under those 4 life areas. That's what we're talking about. And we have 2 paths. One path that those of us on the webinar and myself, Jan, we're on the future path. We understand the nature and effect of planning. And as long as we make our documents while we still understand the nature and effects, so don't put it off, then we are planning for the future in case something happens when we may not understand, right? So we do it now so that these documents, these legal plans will be in place for the future. However, there are some people who are on what I call the need help today path. And I'm going to give you some examples of each of these. So the people on the need help today path their capability to understand the nature and effect of the documents that they're making is in question. So at the time of making them, we're not sure if they understand the nature and effect. They may very well understand everything, but we're not too sure about that. But that was one of the things that was important in the law reform, was to create an opportunity, part of the law, that people could still get help from people in their life that they trusted and who knew them. So there's two paths for personal planning. We'll look at it in a little bit more detail. Don't worry about memorizing everything on this page, on this slide, because we're going to be looking at it as we go along. But what I wanted to get across with this is that there are legal documents specific to each path. So if that's all I can convey, that will be great. That people on the future path are going to be making a legal document to cover health and personal care, and a separate legal document for their financial and legal affairs. And we'll look at those in more detail. People on the Need Help Today path will be, can make what we call a representation agreement, Section 7, that'll cover aspects of all 4 life areas. So they could actually use one document. Those of us on the future path have to do a little bit more work. Okay, let's look at the future path in some detail, because I am trying to encourage all of you to get your affairs in order while you can, while you understand the nature and effect, and tell other people as well. So there's an or, if you notice, that just came up on this slide between the tools under legal and financial. So we have under health and personal, we have the representation agreement, Section 9, plus a separate legal document under legal and financial affairs, but there's an or. So there's 2 documents that people might use to cover legal and financial. And we'll talk about the differences between them. And then under estate planning, you'll see that I'm showing the will. So those of us on the future path are going to make 3 essential documents. That was the name of this webinar. So 3 key documents that we would make so we can sleep at night. We've got things covered. And we're going to look at a couple of examples. So let's take scenario 1, John and Mary. John is relatively healthy. He identifies as a caregiver, so he has some stress worrying about Mary, because Mary was recently diagnosed with dementia. In fact, she took herself to the doctor because she thought something wasn't quite right. However, Mary has actually been John's caregiver for many years. If you were to talk to them, she's the one that's kind of picked up the slack and kept him in good shape. But now he's thinking, oh gosh, I'm going to have to get a little more involved here. I feel like I'm talking about my dad sometimes, because my stepmother had dementia, and that's kind of what happened. Is he stepped up and he was doing much more around those daily chores, hey, that have to be done. It's all possible. So John and Mary are making planning a priority, and I'm sure you hear that from the Alzheimer's Society all the time. That you get that done. There's lots of things to attend to, but the planning you want to do as soon as possible. So what documents would John and Mary make? Well, John and Mary are capable of understanding the nature and effect of the documents they're going to make, so they're on that future path. They each make a representation agreement, Section 9, we call it RA9 for short, to cover the health and personal care matters. And then they each are going to make an enduring power of attorney for financial and legal affairs. And then they each make a will to deal with their estate after death. So here it is on the chart, the RA9, the enduring power of attorney, and the will. So see how there's 3 documents on the future path. They each make those 3 key essential documents. I have another scenario just so we can hopefully see the options. And as Jan said, this may be where you generate some questions. So Cynthia, our scenario 1B, is scheduled for major surgery. Well, of course, there's always risks and benefits, right, of surgery. And this is a motivator for Cynthia because she immediately thinks, well, you know, I want to be prepared just in case. What is she going to do? Well, Cynthia is capable of understanding the nature and effect of the document she's making. So she's going to make the representation agreement section 9 for her health and personal care, right? She's decided to make the representation agreement section 7 for financial and legal affairs because she doesn't have time before her surgery to see a legal professional to make an enduring power of attorney. You don't need a legal professional for any kind of representation agreement. So it's a self-help approach, and Nidus has the forms that people can use. So it's more accessible, which was one of those important principles. And the representation agreement has the powers that a representative can have in 2 different parts of the Act. We call them sections. So that's why you see 9 and 7. They refer to different parts of the Act. So that's what, so Cynthia's getting her affairs in order. She already made a will, so she feels okay about that now. So let's see what she did. She did the representation agreement section 9 to cover health and personal care. She did the representation agreement under section 7 for routine finances. And you can see just by the diagram that the box is smaller than the enduring power of attorney. Doesn't cover quite as much, but it was more accessible for her specific situation at the time. And she already had a will. So again, there's 3 documents, separate documents, to cover the personal planning and the estate planning. Now, Cynthia recovers from surgery, yay! And she's still capable of understanding the nature and effects of the document she's making. So she's going to revise her plan. She reviews her plan for financial and legal affairs. And because remember, she did that, she was feeling the pressure of time. So she's going to revoke her representation agreement section 7, financial legal authorities. She's going to cancel that one, and she's going to make an enduring power of attorney because it covers more and gives her security for the future. And that's really the document that we are encouraging people to make. So Cynthia, she still has her RA9, right? She had made the representation agreement section 7 for financial legal, and she had her will already. So now she's going to cancel, revoke. You have to do something special to revoke. Not hard. We have a form on the website. She's going to cancel the financial and legal representation agreement, and she's going to make an enduring power of attorney to replace it, and it covers more. So I hope that was easy enough to follow with our charts. I'm just going to say a few more things about the representation agreement section 9. We have lots and lots of information about it, but we only have so much time today. So you'll notice that it's under the health and personal care, and it's the most comprehensive, strongest legal document for health and personal care planning. And as I've said, you must understand the nature and effect of an RE9 at the time you're making it. You must be 19 years or older. That's the age of adulthood in British Columbia. So that's something to remember. So this is for everybody, 19 to 119, as I say. And the representation agreement, section 9, is about giving someone legal authority. And what I mean is wishes are not enough. And in fact, many people, a lot of caregivers from the Alzheimer's Society, got involved in the law reform because they were advocating hard about the wishes of their family members or their friends and found that they were ignored. Because the healthcare providers will interpret your wishes or someone else's wishes from their perspective. And so what people realized when we were working on the new law and sharing stories is that actually the key is not the wishes, it's about somebody having legal authority to carry out your wishes. So that is the whole idea behind the Representation Agreement Act and making a representation agreement, is you're giving someone legal authority to do what you would have wanted, to have conversations with the medical experts, to take into consideration your values and beliefs, because you can't predict the future. So people say, well, what if I don't make a representation agreement? If I'm incapable, won't the doctor ask my spouse or adult children to decide? Well, yes. First of all, they have to determine you're mentally incapable, which right away, you know, gives people labels, and we're trying to avoid that. But if they've decided that you are mentally incapable of consent, then they could select someone. There's a list in the law, spouse is top of the list, and then they can look at an adult child for some healthcare matters. It doesn't cover as much as if you made a representation agreement. And they don't have the same authority. Your spouse doesn't have as much authority as a spouse that they would if they were your representative. So for example, if you didn't make a representation agreement section 9, then the medical team has to agree with your spouse. If they're saying, Joanne wouldn't like this, don't give her that treatment. So my spouse can't refuse life support for me unless the majority of the medical team agrees. But the medical team might not know me, right? But if I name my spouse in my representation agreement section 9, then my spouse has authority, the final say, to refuse life-supporting health care for me. And it doesn't require agreement of the medical team or other people. Obviously, my spouse is going to get the medical opinion, but my spouse has the final say because they know me. And it would work the same for an adult child. So my point is the representation agreement is your way to stay in control and have a say, and it makes it a lot easier on your spouse, on your children, on your friends, whoever it is that you're wanting to step up for you and the person that knows your wishes. Maybe, now I was talking about healthcare. Remember the RA9 covers healthcare and personal care? Personal care is huge, right? That's about the things that are, the daily things that are important to us. And there's no sort of default law about personal care. So maybe your spouse and adult children will be able to make some of those decisions. But really the representation agreement is the only legal way to give someone authority for those areas. Then people say, well, what if I make an advance directive? And frankly, when I got involved many, many years ago, I kind of thought like this too, right? It's a list of instructions. What if I just write down things that I want or don't want? Well, it didn't take me long to figure out that I'd never get the job done. And it was actually really, really hard to do. So first of all, you have to be determined incapable before a healthcare provider can look at an advance directive. The advance directive law says that it only applies to healthcare, not personal care matters. So it can't say anything about facility placement or arranging support services so I can stay in my home as long as possible. It has nothing to do with that, only healthcare. And it's only going to apply to very, very limited healthcare situations. Even a diagnosis of dementia does not predict your specific journey and the kinds of decisions that might come up. So you can see why there isn't enough paper to write down all the possibilities. And of course, a piece of paper cannot advocate for your wishes. So that's what's really different about making a representation agreement. I told you it's about giving somebody legal authority. It's really about an advocate having some legal clout to carry out your wishes. And we actually don't have to worry about capability because they're there to help you at the times that you need help. And the agreement can go back in the drawer if you can do things yourself. So we don't have to label people when there's a representation agreement. It's our support and safety net. I have a couple of alerts here for you. Hope I'm not overwhelming you, but I know that people have different experiences, and it's my one chance to let you know some things. So I'm calling this kind of consumer beware. Physicians' orders are an old practice, and they haven't changed yet. But I need you to know they're not a legal advance consent, even if they're being used like this, and even if sometimes you'll see things written on the government websites about it. But there's something called the Medical Scope of Treatment form, the MOST form, or a DNR, no CPR form. These are actually physicians' orders. They're not a way that we as the public or patients can give our consent. So I need you to know that so you don't think, oh, I filled that out so I don't have to do anything else. You actually really need a representation agreement. These documents don't fit in the legal scheme. But they're you know, sometimes it's things, they're used just because they have always been used. And so my point is that specific wishes, I'm not saying you shouldn't talk about your wishes, but you want to be talking about them with your representative and your alternate representative, because they can only be done by you, right, by the person when you're capable, and they belong to you, right? So you don't write them out and give them away to the doctor to put away in the chart. They belong to you. You need to give them to your representative and your alternate. And I just wanted to let you know that we're going to be doing a webinar on that topic, expressing wishes that don't backfire, because unfortunately we've seen some examples, and I've had a referral from one of the Alzheimer Society regions where someone unfortunately wrote something down in their representation agreement and it backfired. So I want to tell people about those things. Another alert, you may have seen this booklet called My Voice, and I know the Alzheimer's Society receives support from the Ministry of Health, but you know, there are different departments inside the Ministry of Health, and they don't all know what each other's doing. One of the departments produced this booklet as a guide to advanced care planning. Now, they produced it in 2012. We've been helping people learn about the law and make representation agreements for a long time, and the law came into effect in February 2000. So this is kind of late in the day that they produced this book. as a first effort, it's you know, what you would expect. But unfortunately, we're a long ways in, and it's very confusing. And some of the information is not accurate, and there are some forms in it, but they're not accessible enough. And that's actually one of the forms where I told you that somebody used it and it backfired. They used it and wrote something down and it backfired. It was one of the forms from My Voice. Now, the Ministry of Health knows there's problems because they called me in 2013 and we discussed it. I understand that this booklet's being revised, but I think it's still in just one department inside the Ministry of Health. And if you remember my diagram way up front, that we have to always have in mind all 4 life areas when we're talking about this topic, you'll maybe see why I have some reluctance and hesitation about the new version, whatever that is. So I've told you a couple of times that we have lots of information on our website. We also have Representation Agreement Section 9 form. We made it available on our website because we knew the forms put out by government were not accessible enough and not best practice, which is what we're interested in. So you can find this information on our website. You don't need a legal professional. We provide instructions. And of course, we'd like to encourage people to register when they're finished. And here's where you're going to find it. So all of us on that future path, if you go to the Nidus website, you're going to click the middle photo or heading. And that's where you'll find information and the RA9 form. Okay, let's go quickly through the financial and legal side, because we've been talking about the health and personal care side, right? And on the financial legal side, there were 2 documents I mentioned to you, and I had an or in between. So let's look at that now, and we'll look at some of the differences. There's the or between the enduring power of attorney or using the representation agreement under Section 7, that part of the Act, where it lists routine financial legal affairs. And just as an introduction, I'm just going to point out that a power of attorney is not the same as an enduring power of attorney. A power of attorney ends if you become mentally incapable. Unfortunately, a lot of legal professionals, financial advisors, others, keep using the term power of attorney even if they mean enduring power of attorney. And that doesn't help us in the public realm. It's very confusing and very stressful because we wonder what we have. Maybe we don't have everything we need. So Nidus has a fact sheet that explains the difference and explains what wording to look for in your document. Because most of us would want to make an enduring power of attorney because it will endure or continue to be in effect even if we become mentally incapable, whereas the power of attorney ends if we become mentally incapable. So an enduring power of attorney is the most comprehensive legal planning document for financial and legal affairs. You must be capable of understanding, there's 6 items outlined in the legislation. Things like you have to understand what you own and the approximate value. You have to understand your legal obligations, so if you have a spouse and minor children. You have to understand that the person you appoint in your enduring power of attorney can do anything you can do for financial affairs. And of course, you must be 19 years or older to make this document. We have a guide for making an enduring power of attorney, and we have a fact sheet about the authorities in an enduring power of attorney. And those are both, the idea of those are to help you get organized and prepared in your thinking and discussions with others. And then you would go to a lawyer or notary public because they'll make up the form for you. And then we hope you will register it, and we'll get to that a bit later. Now, the other option I mentioned was using the representation agreement under Section 7, covers routine financial and legal affairs, which is not as much as the enduring power of attorney. So routine is defined in the law as to what it covers and doesn't cover. It doesn't cover dealing with real estate. It doesn't let the person use your money for someone else's benefit. And, you know, frankly, if you have a spouse and anyone that you support financially, even occasionally you give them some money, you should be making an enduring power of attorney. Because the representation agreement under Section 7 won't allow the person you name, your representative, to use your money to help your spouse or to help minor children or other dependents. So this option is really for very specific situations, but I need to tell you about it because it is an option. And you must be 19 years or older to make it. The representation agreement, Section 7, requires an extra safeguard if finances are part of that agreement. So if you're doing it for the routine finances, you can either name someone as a monitor or have at least 2 representatives and say they must act jointly. You need special wording for that. But that's, they sort of monitor each other. So that's how you have an extra safeguard, and the law requires it. The only exception is if the representative is your spouse. But of course, if you name an alternate, which we would recommend, then you're going to need to satisfy the safeguard requirement. So you're always going to need at least 2 people if you're going to use the representation agreement for financial and legal affairs. But I think I pressed the wrong thing. Oh dear. Okay, we have information and a form for this document if that's, you know, what people decide fits for them. No legal professionals required. We also have a chart that compares the enduring power of attorney and the RA7 financial legal. And of course, we hope you'd register the completed document. And I think the chart is one of the handouts that Jan has made available. Yes. So again, I'm showing you a screenshot from our website, from the home page, and you'll find information about the enduring power of attorney or the RA7 FNL that we were just discussing by going in the middle photo, clicking on the middle photo or heading. And here's the place that I'm going to just alert you about joint ownership. I mentioned that when I was talking about the will. When we're alive, people sometimes think of putting someone else joint, you know, when their spouse dies, or maybe they never had a spouse and they're getting older and they think, oh, well, I'll, you know, add somebody to my bank account or put them joint on with my vehicle or the real estate. And we're saying, don't do it. If they're not your spouse, don't do it. Because there are some, you know, very critical issues, like creditors can come after your joint asset. We have court cases now where maybe, you know, mom put one of the children joint on the bank account, but, you know, the question, mom dies, and so the daughter whose name's on the joint account takes ownership of all the money, but maybe mom meant it to go to other beneficiaries as well. So you don't want to set that up for people. It's not, it's costly, and it can be very disruptive to relationships. And of course, joint real estate now is a much more challenging issue as the property rates are higher, the real estate is much more valuable, and so when it's sold, the joint owner who doesn't live in that, never lived in that house, is going to have to pay capital gains report on their income tax. We're going to write a fact sheet about this because there's a lot more to say, but I'm just trying to alert you not to do it. And I'm also going to alert you about the bank power of attorney. I know that the financial institutions have these forms and they love them. It's just like the physician's orders. It's an old practice. It's not sufficient for personal planning, and it can interfere with the more general planning that you do. So, you know, I'm really carrying the message for the legal professionals because they're becoming increasingly concerned about these bank powers of attorney. So don't do it. And if you have done it, get some help to cancel it, because you don't want to accidentally cancel something else that you're hoping will be in place instead. What if someone's on that other path? So I'm just going to very quickly talk about the Help Today path. So this is for people whose mental capability is in question. And in BC, the law is that if you're 19 years or older and you need help, you're going to be vulnerable to adult guardianship, which is for some reason called comitationship in British Columbia. So who's most vulnerable or affected? Well, adults who have a disability from birth or childhood. So from birth, we used to refer to that as mental handicap. Some people, we're not sure if they understand the nature and effect of the documents. But another group that's very vulnerable are people who were considered capable, but they didn't make plans when they were on that future path. Now they need help. So maybe somebody with advanced dementia or had a massive stroke. So the law reform was really about filling that gap. Remember, I talked about we had a gap. There was nothing to be an alternative to adult guardianship. So that's what we did. We wanted everybody to be treated with respect and dignity, even if their capability to understand is in question. They're still a person. Because under adult guardianship, you lose your rights. Some people call this civil death. Legally, you're a non-person. Your signature doesn't count. Now, I know that they've tried to you know, modernize and pretty up guardianship, but guardianship is guardianship is guardianship. And it's not something people want. And in BC, it's the last resort. Because when you're under guardianship, you're going to have the government involved in your personal and private affairs. Either they're going to be involved directly as your statutory property guardian, which just means they're managing your finances and legal affairs. They take over control. Or they'll be involved indirectly if a spouse or family member applies to court to be your guardian. They have to report to the public guardian and trustee how they're managing your affairs. And I used to work at the Alzheimer's Society many years ago, and it was always pretty heartbreaking to hear the stories of a spouse or an adult child saying how they felt like they had to account for every piece of Kleenex or tube of toothpaste that they bought for their spouse or their mom or dad when they were acting as the guardian. So the alternative I'm going to tell you about was what we worked on with the law reform. So let's take scenario 2. In scenario 1, Mary was just diagnosed with dementia. She was making her plans, but maybe her dementia's progressed and maybe she never got around to making her plans when she was considered capable. And she no longer meets the capability requirements for making an RA9 or an EPA on the future path. So what can she do? Well, that's what the Representation Agreement Section 7 was designed for. So you can see that it covers aspects of all 4 life areas. Not as much as the RA9 and the Enduring Power of Attorney, which is why I'm telling you on the future path to do that before it's too late. You can always cancel it and make a new one when circumstances change. But if you have nothing, then you've lost that opportunity. Or you may have, unless you regain your capability. So just to say that the RA7 has a different view of capability than other laws or documents, there's no specific criteria everyone has to meet. So even people in a care facility can make an RA7. They're going to need help maybe to make it, but the law allows them to. Even if a doctor says Mary is mentally incompetent, that does not prevent her from making an RA7. And we have information and a form, of course, on our website. And where would you go? So you go to the home page at Nidus, and if you are helping someone who has a disability from birth or childhood, then you click on the first photo or heading. If you're helping somebody like Mary in scenario 2, who, you know, didn't get their planning done or not enough, or the right things, then you will click on the third photo or heading for someone whose capability is in question now. And how do you let people know what you've done? That's where the registry comes in. And I'm just going to quickly show you. It's also, you can access it through the website. You go to the Nidus website and click registry at the top, and you'll come to a page with lots of information. And then you can click online registry. You'll see in the right sidebar there, and that'll take you to the secure registry site. And most people will start at creating their account. I do webinars on this, so you can get lots more detail. And just to say that the registry is all about communication, because as everybody tells me, from the ER doctor to the financial institutions to the public guardian trustee, you can never have enough information. So the registry lets you store information and documents in one place, and it's different from the wills registry because not only can you store a copy of your document, but you can actually go in and update information. And then you can make your registrations available to others, like authorized third parties and to specific individuals, maybe like your representative, your alternate, maybe your physician. You can print as many wallet cards as you want right from the registry. And this one has been printed in color and laminated, and it fits right in your wallet. And why register? Well, it's for yourself, obviously, because I told you, how can people carry out your wishes if they don't know them? But it's also those people who are trying to help you, and they don't have to rummage around trying to find documents and information that they need. Because, you know, you're not thinking straight when a crisis happens. You need help, and the registry can help with that. So I'm